Hi friends, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. So today we're going to be talking about an interesting case out of the 8th Circuit Court of Appeals. The 8th Circuit Court of Appeals, as you can see here, has a number of different states in it, and one of those states is Minnesota. And Minnesota is a state that has very strict gun laws. And they applied their gun laws against anybody under the age of 21 receiving a conceal and carry permit. And the 8th Circuit has analyzed this now. I suspect it may very well go up to the Supreme Court, and it might very well get overturned, but I will explain why here in just a moment. Let's take a look at the opinion. This is Kristen Worth, Axel Anderson, Minnesota Gun Owners Caucus, Second Amendment Foundation, and Firearms Policy Coalition. They are the appellees. In other words, they won at the court below. And the defendant appellant is Bob Jackson in his individual capacity as the Commissioner of Minnesota's Department of Public Safety, essentially their state police. And there's all kinds of amicus briefs from anybody from the Giffords Law Center, Brady Center to Prevent Gun Violence, Everytown for Gun Safety. There were a lot of people who weighed in this case, including the National Rifle Association. So this is an opinion by Judge Dwayne Benton. Now, again, full disclosure, I actually clerked at a time when Judge Dwayne Benton was on the Missouri Supreme Court. He had been appointed there by John Ashcroft. And I thought he was a very good judge, particularly in the tax cases, because he had been the director of revenue. He had a background in accounting. He was a pretty sharp guy. And for the most part, he was very conservative. I enjoyed working with him on different cases. He usually would come down to Judge Robertson's chambers where I worked, and he'd ask a question or two. He usually came in to see Judge Robertson, but he would still stop and say hi to me and ask me questions or tell me what's going on, that sort of thing. He was a very friendly judge, very good judge. And then he got sent up to the 8th Circuit Court of Appeals, and that's the first time I ever had a real disagreement with Judge Benton. And the reason I had a real disagreement with him is because I had a False Claims Act case up there, and he just did not analyze the case right. Now, I'm sure he thinks he analyzed the case right, but multiple other appeals from other circuits have indicated to me, and hopefully to him, that he got it wrong. But even if that's not the case, judges are entitled to make mistakes just like everybody else. And hopefully, whatever he's done has made him a better judge. And I think in many respects, he got this one right. And I want to remind somebody of something that I think is really important, and that is that when a judge decides a case, the rules of the decision are determined by what the parties argue. So if there is a circuit court rule or a rule of civil procedure or a statute that's directly on point, and somebody doesn't argue it, and the court doesn't on its own find that statute, then the fact that there are omissions in the record and omissions in the argument might very well cause the court to reach the wrong conclusion in the particular outcome of the case, and it might not have reached that result if the parties had argued all of the proper things. So when you set up an appeal, one of the things you have to do is you have to establish what the issues are. And if you don't list something as an issue, then it's not going to figure prominently into the opinion. And even if it does figure into the opinion, it will probably be considered to be dicta because it wasn't raised by the parties. But with that understanding, let's take a look at this particular case and why I think it's interesting and something that may very well have been blown by the Attorney General in the state of Minnesota. So here's the Opening part. Minnesota's permit to carry statute, among its objective criteria, requires that applicants be at least 21 years old. 3 gun rights organizations, the Second Amendment Foundation, all these people, they challenged this age restriction for violating the Second and 14th Amendments. The district court granted summary judgment to the plaintiffs, finding the Second Amendment's plain text covered their conduct and that the government did not meet its burden to demonstrate that restricting 18 to 20-year-olds' right to bear handguns in public was consistent with this nation's historical tradition of firearm regulation. Minnesota appeals, having jurisdiction under 28 U.S.C. 1291, that's the general jurisdiction statute, this court affirms. The Minnesota Citizens Personal Protection Act in 2003 criminalized carrying handguns. To get a permit to carry, you have to be at least 21 years old. That's been the law since 2003 in Minnesota. So the individual plaintiffs want to carry handguns in public. The district court found, except for failing to meet the minimum age requirement, they were otherwise eligible to receive a permit to carry a pistol in Minnesota. Organizational plaintiffs collectively have thousands of members in Minnesota. The plaintiffs sued the commissioner. The plaintiffs allege the Minnesota statute's unconstitutional facially and as applied to the individual plaintiffs. So this footnote is rather interesting. The commissioner tries to invoke sovereign immunity. And as we've said before, sovereign immunity, based on the Old English tradition that the king could do no wrong, essentially provides that the state cannot be sued in many respects. And indeed, if somebody was challenging a discretionary decision that resulted in personal injury, that would certainly be the case. The court says if sovereign immunity applies, then this court must dismiss the claims for lack of subject matter jurisdiction. Under Ex parte Young, 11th Amendment sovereign immunity does not apply, and a private party can sue a state officer in his official capacity to enjoin a prospective action that would violate federal law. And of course, the Constitution is the ultimate federal law. For a defendant to be amenable to a suit challenging a particular statute, the defendant must have some connection with the enforcement of the act. The district court properly found the commissioner had some connection with enforcing the statutory scheme. The commissioner, under Minnesota's permit statute, has several duties connected with the statute's enforcement, making application forms available on the internet, providing relevant data to the sheriffs, and so on. So they found that sovereign immunity wasn't going to fly as a defense. So the plaintiffs were asking for a lot of relief here. They wanted to declare that the regulations and all related laws, policies, practices, and customs violate facially as applied to the otherwise qualified 18 to 20-year-olds and 18 and 20-year-old women, the right of plaintiffs and plaintiffs similarly situated to keep and bear arms. And they wanted to enjoin the defendants from enforcing that statute. The district court applied the two-part test in New York State Rifle and Pistol Association versus Bruin, a textual analysis of the Second Amendment to a historical analysis of the nation's tradition of firearm regulation. The district court ruled that the plain text of the Second Amendment covered the plaintiff's conduct because 18 to 20-year-olds are among the people, and the Second Amendment presumptively guarantees plaintiffs the right to bear handguns in public for self-defense. It granted summary judgment to the plaintiffs, declared the age restriction facially unconstitutional, and enjoined enforcement against them. The district court, however, stayed the injunction pending appeal, and so she let this go up on appeal to the Eighth Circuit. So Judge Benton says the court reviews a de novo, a grant of summary judgment, and this is a facial challenge. The individual circumstances are not as important as the carry ban, must be unconstitutional in all its applications to 18 to 20-year-olds. And that's based on both Eighth Circuit precedent and Supreme Court precedent, as you can see there. To counter a facial challenge, all the government has to do is identify constitutional applications using the same text and historical understanding framework. All the individual plaintiffs are now over 21 years old because it takes forever to get a case up on appeal. Their claims, by and through whom the organizational plaintiffs had standing, are moot. To avoid mootness of the entire case before the last individual plaintiff turned 21, plaintiffs moved to supplement the record with an affidavit of Joe Knudsen, a 19-year-old Minnesotan seeking a permit to carry who is a member of all three organizations, in order to continue the standing of the organizational plaintiffs. The organizational plaintiffs assert standing solely as the representatives of its members. And to have standing, you have to be members would otherwise have standing to sue in their own right. The interests it seeks to protect are germane to the organization's purpose. In other words, you couldn't have the flower shop owners of America up here. You have to have these people who are engaged in Second Amendment advocacy. And C, neither the claim asserted nor the relief requested requires the participation of individual members in the lawsuit. So, as for A, they said that the organizational plaintiffs have demonstrated at least one of their members has had continuous standing. As for B, each organizational plaintiff's purpose is to promote gun rights, and as for C, plaintiffs assert that the carry ban is facially unconstitutional, and the relief sought is a permanent injunction on its enforcement. Neither requires an individual plaintiff's participation in the lawsuit. So, Minnesota doesn't contend that the organizational plaintiffs failed to meet the standing test. Instead, it says you shouldn't be able to supplement the record below because they don't have any evidence about Knudsen. But they do have evidence. They have an affidavit. And essentially what they decide is once standing has been established, the plaintiff's personal situation becomes irrelevant. Specific to mootness, courts may consider any evidence bearing on whether the appeal has become moot. And they decided that it hadn't become moot. The court grants the motion to supplement the record and denies the related motion to dismiss the appeal. The organizational plaintiffs have an unbroken chain of standing through Knudsen. The Second Amendment reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Supreme Court in Heller recognized that the Second Amendment's right to keep and bear arms protects an individual's right to possess a firearm unconnected with service in a militia and to use that arm for traditionally lawful purposes. That's the Heller decision. It's always been widely understood that the Second Amendment, like the First and Fourth Amendments, codified a pre-existing right, the natural right to resistance, self-preservation, and defense, not merely a common law right. The Supreme Court has applied that right against the states through the 14th Amendment, with a plurality incorporating it through the Due Process Clause, and Justice Thomas recognizing it as within the Privileges or Immunities Clause. We hold, therefore, the Due Process Clause of the 14th Amendment incorporates the Second Amendment right recognized in Heller. Consistent with Heller and McDonald, Bruin held that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. The Heller opinion demands a test rooted in the Second Amendment's text as informed by history. Then the court notes that the Bruin court provided a new test to evaluate the Second Amendment. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with the historical tradition can a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. The test, then, has two parts, text, then history. One, if a focused application of the normal and ordinary meaning of the Second Amendment's language covers an individual conduct, then the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. First, this court conducts a textual analysis determining if the amendment's plain text covers the plaintiffs. Are they a part of the people with a right to keep and bear arms? If so, then the conduct is presumptively protected. Second, the burden shifts to the government to demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation. When the government regulates arms-bearing conduct, as when the government regulates other constitutional rights, it bears the burden to justify its regulation. That's the Rahimi case. The court analyzes the government's identified historical analogs, whether the government identifies a well-established and representative historical analog, not a historical twin. If the regulation is consistent with the nation's historical tradition, it does not infringe the right of the people. If not, then the regulation improperly infringes the individual right to keep and bear arms. And then they go into the analysis. Bruin does not command us to consider only conduct in isolation and simply assume that a regulated person is part of the people. Instead, we must begin by asking whether the carry ban governs that conduct that falls within the plain text of the Second Amendment. That is, Bruin tells us to begin with the threshold question using the plain text, are the plaintiffs part of the people? Minnesota asserts that law-abiding adult citizens that are 18 to 20 years old are not members of the people, and thus the plaintiffs are not protected under the plain text of the Second Amendment. Now, if you want to lose credibility with an argument in front of an appellate court, the best way to do it is to make a completely baseless, strained claim. And if somebody is 18 years old, they're eligible to vote. In the great song from the 1960s called Eve of Destruction, there's a line that Barry McGuire sings where he says, "You're old enough to kill, but not for voting." They drafted people who were 18 and sent them to Vietnam. So, the idea that they are not part of the people when the government issues them weapons is just, it doesn't pass the straight face test. And you got to wonder why they made such a strained argument. Minnesota argues that 18 to 20-year-olds are not members of the people because at common law, individuals did not have rights until they turned 21 years old. Ordinary law-abiding adult citizens that are 18 to 20 years old are members of the people because 1, they are members of the political community under Heller's political community definition. 2, the people has a fixed definition, although not fixed contents. 3, they're adults. And 4, the Second Amendment does not have a freestanding, extra-textual dangerousness catch-all. First, the right to keep and bear arms is not a right granted by the Constitution. Neither is it in any manner dependent upon that instrument for its existence. The Second Amendment declares that it shall not be infringed. The people codified that right and that political tradition in the Constitution. Heller recognizes the universal applicability of that right to all Americans. Heller and Bruin command focus on the normal and ordinary meaning of the text of the Second Amendment. Minnesota must overcome the strong presumption that the right applies to all Americans. Further, the term unambiguously refers to all members of the political community, not an unspecified subset. 18 to 20-year-olds are included in the political community. They are people who compose the community and who, in their associated capacity, have established or submitted themselves to the dominion of a government for the promotion of their general welfare and the protection of their individual as well as their collective rights. Second, Minnesota asserts that because 18 to 20-year-olds did not possess all their civil and political rights as minors at the founding, they cannot be considered members of the people. Arguments of this type, focusing on the original contents of a right instead of the original definition, that is, that only people considered to be in the political community in 1791 are protected by the Second Amendment instead of those meeting the original definition of being within the political community, are bordering on the frivolous. We do not interpret constitutional rights this way. Although its meaning is fixed with the understandings of those who ratified it, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated. So even if Minnesota were correct in its assertion about the political community's definition, the contents that define term have changed. Since the 26th Amendment, prescribing the abridgment of voting rights based on age for those over 18, they've been in the community, the national political community, and that's what the court holds. And interestingly enough, I think we'll see in a moment that the state put up some evidence that said that a lot of the crime that's committed with firearms is committed in the 18 to 20-year-old age group. But the court says, importantly, the Second Amendment's plain text does not have an age limit. In other words, the founders considered age and knew how to set age requirements, but placed no restrictions on rights, including those protected by the Second Amendment. Ordinary law-abiding 18 to 20-year-old Minnesotans are unambiguously members of the people because the plain text of the Second Amendment covers their conduct. It is presumptively constitutionally protected and requires Minnesota to proffer an adequate historical analog consistent with the nation's historical tradition of firearm regulation. So the court decides, look, these are members of the people. And of course, they had to make that decision because, like I said, they can vote. They're a member of the political community. So the question then becomes whether or not there is this, what they call regulatory straitjacket. Minnesota does not need to provide this court with a dead ringer. A court must ascertain whether the new law is relevantly similar to laws that our tradition is understood to permit. So, Minnesota proffers 3 reasons the carry ban survives. 1, a freestanding catch-all for groups the state deems dangerous. And 2, founding era and common law analogs. And 3, Reconstruction analogs. So Minnesota contends that status-based restrictions from the founding era created a freestanding dangerous catch-all analog. And assuming that historical regulation of firearm possession can be viewed as an effort to address the risk of dangerousness, this risk did not justify the carry ban. Minnesota claims that 18 to 20-year-olds present a danger to the public, but it's failed to support that claim with enough evidence. According to the report filed by Minnesota, the murder arrest rate for 18 to 20-year-olds is almost 33% higher than the murder arrest rate for the next most homicidal age group, which is kind of funny when you think about having a homicidal age groups. And they are most likely of any group to use firearms to commit homicides. Even if we had no reason to doubt the accuracy of the statistics, they don't support the carry ban. For another, Minnesota has not attempted to explain why its other statutory restrictions, none of which the plaintiffs have challenged, do not reduce the risk of danger already. Permit applicants must complete training in the safe use of the firearm, and they must not be listed in a criminal gang investigative data system. What the record lacks, in other words, is any support for the claim that 18 to 20-year-olds who are otherwise eligible pose such a credible threat to physical safety that the Second Amendment right may be burdened. They decide it doesn't. A legislature's ability to deem category of people dangerous based only on belief would subjugate the right to bear arms in public for self-defense to a second-class right subject to an entirely different body of rules than the Bill of Rights guarantees. Founding era sources, the common law, college run rules, and municipal regulations. Minnesota reiterates that at common law, 18 to 20-year-olds were restricted because they were minors. That doesn't fly either. Inverse evidence of common law is not a sufficient analog to meet the state's burden. Second, Minnesota cites college rules restricting students from possessing guns on campus, discussing rules from Yale, which is a private university, the University of Georgia, which the last time I looked is not located in Minnesota, and the University of North Carolina, which also, I'm pretty sure, is not located in Minnesota. These rules are very different in their how, and the school procedural rules are not laws subject to constitutional limitations. Further, a restriction on the possession of firearms in a school, a sensitive place, is much different in scope than a blanket ban on public carry. Minnesota's proffered founding era analogs do not meet its burden. And then they make 4 arguments why Reconstruction era evinces a historical tradition of firearm regulation, unprecedented social concerns in the second half of the 19th century, Reconstruction era and late 19th century statutes, the 19th century state court cases, and 4, that as a long-standing prohibition, the carry ban should be considered presumptively constitutional. As discussed, it is questionable whether the Reconstruction era sources have much weight. First, Minnesota argues the market revolution between the founding era and the Reconstruction era made pistols more accessible. This court, therefore, must take a nuanced approach. Whatever the likelihood that handguns were considered dangerous and unusual during the colonial period, they are indisputably in common use for self-defense today. And the court goes on to look at all of these, and it essentially concludes, no, Minnesota has not met its burden to proffer sufficient evidence to rebut the presumption that the 20-year-olds and 18 to 20-year-olds seeking to carry handguns in public for self-defense are protected by the right to keep and bear arms. The carry ban violates the Second Amendment as applied to Minnesota through the 14th Amendment and thus is unconstitutional. The judgment is affirmed. Now, back to what I started with. There is one thing that is left out of this opinion and apparently was left out of the actual argument on this case, and that is 18 U.S.C. section 922B. Let's take a look at that. It shall be unlawful for any licensed importer, licensed manufacturer, licensed dealer, or licensed collector to sell or deliver any firearm or ammunition to any individual who the licensee knows or has reasonable cause to believe is less than 18 years of age, and if the firearm or ammunition is other than a shotgun or a rifle, or ammunition or shotgun or rifle, to any individual who the licensee knows or has reasonable cause to believe is less than 21 years of age. So while an individual can obtain a rifle or a shotgun when they are between 18 and 21 years old, they can't walk into a gun store and buy a pistol when they are in the age range between 18 and 21. Now, why this wasn't argued by the state of Minnesota is absolutely beyond me. I would think that this would be a really important thing to bring out to the court. Unless, of course, the court is prepared to strike down this age restriction, which is in federal law. And there have been a lot of attempts to try and strike down parts of 922. The Rahimi case tried to strike down the domestic abuse thing, and they lost on that because the court felt that was important. The Supreme Court felt that was important. So the idea that you have this problem here where you have 18 to 20-year-olds who can't buy a pistol being authorized to carry a pistol, there is a logical disconnect in there somewhere. Now keep in mind, I am a Second Amendment absolutist. I believe if you're old enough to carry a gun for the Army, you're old enough to carry a firearm for yourself. But that's not the way the federal law is written right now, and it just amazes me that nobody brought this out in argument or in briefing before the Eighth Circuit Court of Appeals. Now, if they take this up to the Supreme Court, and if the Supreme Court determines that this is the case, that there's no reason to exclude 18 to 21-year-olds from the protection of the Second Amendment, then 922B is going to go away. So there are risks for the state, frankly for all the states, if they take this up, and hopefully they won't do that. And of course there are risks for people who who want to carry firearms if they take it up. I mean, it could go badly either way. And so this is a really perplexing thing for me. Maybe somebody who was involved in this will be able to tell us later on. But generally speaking, I think Dwayne Benton got this right. Judge Benton is a good man. He is a wonderful person. He may not necessarily understand the False Claims Act as well as I would like him to, but hey, we're going to let bygones be bygones, right? I think they got this mostly right. And again, if the parties didn't raise it, the court has absolutely no responsibility to bring it up on their own. Although I would find it difficult to believe that one of the clerks didn't find this and talk to somebody about it. That could still very much be the case. And as those of you who have been following along know, I always try to do a little TLDR to let you know what happens. It's too long, didn't read. Here's the deal. Are 18 to 21-year-old Minnesota citizens part of the people covered by the Second Amendment? The court says yes. Does a ban on carrying handguns for 18 to 21-year-olds comport with the historical traditions of firearms regulation in the United States? The court says no. And then finally, the result. The court affirms and strikes down that portion of the law and enjoins enforcement against the plaintiffs. Thank you so much for watching. If you have any comments, drop them in the comments down below. Like, share, subscribe, all that stuff everybody always asks you to do. If you have the opportunity today, go out of your way. Do a kindness for somebody. Maybe send them a get well card. Who knows? There are lots of things you can do in an average day that make people happy, make them feel good. Tell somebody you like the way they're dressed. Tell them you like their shoes. Doesn't have to be a big thing. Anything you do to make somebody's day better makes our world a better place. Thanks for watching. After you do a kindness for someone, come on back down here tomorrow, catch me at the beach, and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.